Okay, thank you very much. I am certainly pleased to be here and have the opportunity to talk to everybody. And I'm certainly pleased to be back on the family court docket as of the 1st of this year and have another chance to work with Lynn and all the good people we have at the Macomb County front of the court. I wanted to talk a little bit about myself, and I wanted to go first before Lynn because I think it's important, at least for me, to speak to you while it's still cold in here and you're all nice and bright-eyed. I ran for office the first time in 1988, and the big surprise to me was the people that worked the hardest on my campaign, much to my surprise, were people that I had represented them in their divorces. And they weren't really people that I thought I had done some great job for. They weren't cases that were unusual in any respect other than, I realized I helped them through a really difficult time in life. Maybe I kept my mouth shut about something they told me, but that made an impression on me. This is a very important thing that we do to help people through these failing situations in what's maybe the most important thing in life. Custody litigation is different than all other litigation. In one sense, it's kind of nastier than most other litigations. My bailiff, when I told him we're going back to the family docket, he said, I'm going to have to hit the weight room again. You can send these guys to prison and they're used to the courtroom and they do, they know the routine, but when you tell them they can't see their kid this weekend, Brian went back to the weight room. You're stuck as a judge in a custody case that the litigants can sink your decision. If they don't have, if the process doesn't lend itself to some sort of cooperation between them, you can make the brightest decision in the world. It's not necessarily going to work out the way you want it to work out. Status conferences. We talked about status conferences earlier. We have a difference of opinion within the court. The judges, I think, are tending toward not having the litigants appear. Dave Elias insists that they appear. And I think I'm quoting Dave accurately that the status conference properly done provides a roadmap to resolve the entire case. Okay? At the bench bar conference last month, I think the consensus among the lawyers was they don't want their clients to appear at the status conference. It gets in the way. And I see some heads nodding affirmatively. If you want to tell Dave what you think, go right ahead. I think I'm satisfied that I know what the bar thinks at this point. I would never come back to the family docket if it weren't for Lynn, actually. And I very much enjoy working with Lynn. And I'll turn it over to her.
Thank you. If you have a proposed ex parte order, make sure you file the judgment information form. That's not listed on there on any case that involves parenting time, child support, or spousal support, or custody. That's the front of the court form 100. In the motion practice, at the front of the court in Macomb, we have judicial service officers that are all attorneys now, and when we have order to show cause hearings on child support, parenting time, medical issues. Medical issues are done by medical enforcement people. They are not attorneys, but the other JSOs are. They're all heard by the JSOs. They try to settle the matter. If it's not settled, it is then referred and sent down to the court for a hearing by the judge, and that happens on the same day. At the time of the presentation of the judgment fee needs to be paid, so sometimes the court clerks really would appreciate if counsel would bring verification that the judgment fee's been paid before the judgment gets entered. And that's a courtesy based on what the clerks have asked me to ask. It's real important when you enter your uniform child support orders now that you get a very good number for overnight parenting time. So I think it's real important that you deal with your clients to get a good estimate, because it does affect the support. When it comes to child care, The guidelines also indicate that as of August 31st, upon the 12th birthday of the child, that child care stops. But as a practical matter, when you're entering your judgment of divorce, it's incumbent upon the custodial parent to let the office know if there's extenuating circumstances, or if for some reason child care is supposed to stop before the 12th birthday and they don't know, they do not notify the front of the court, and the other side usually will come in and complain, but if they're not sure and it doesn't happen, you might want to include in your judgment of divorces a statement that because of the no retroactivity clause, that in child care purposes only, that if the custodial parent fails to provide notification that a modification or termination of child care costs should have been done earlier, that it could be done retroactively. In Macomb, the bench has adopted a policy, and we've had it in effect for a lot of years. It's really come into full force now because of the economic downturn. But when a payer of child support becomes unemployed or disabled, it is really important that you tell your clients that they come in to see their judicial service officer as soon as this happens, and we will file a petition for them for adjustment. Many of you that practice in Macomb, you'll hear the JSOs talk about PASAs. That's what that means, petition for adjustment of a support arrearage. Once that's been filed, and then the payer is able to return to work on a full-time basis, or it is determined what the disability pay is receiving, they will allow them to pay a lesser sum of support until such time as they're back to work. The other side can always file objections, and at that time the matter goes before the court. This policy adopted by our bench has saved our referee side a lot of work, and has also saved our judges and our family division a lot of motions that do not have to be paid. And the parties that are filing these motions, it saves them money from filing a fee. So it's real important that they contact their judicial service officer whenever there's a change in circumstance where there's a separation of work. Opting out of the front of the court, all prejudgment cases in Macomb are not allowed to opt out. Once a judgment's been entered, if they want to opt out, they can. That alleviates all front of the court services. The parties, they come at a later time and want an investigation done, that would have to be done by outside sources, not the front of the court. If they opt back in Macomb, they have to come in for a full year and will not be allowed to opt out again. The front of the court in Macomb also has liberal walk-in hours. The office is open from 8 till 5. We even have the office is open for walk-in availability during the lunch hour on a limited basis. Also through phones. One policy we've changed recently, and that's because of budget constraints. All parenting time requests are required to be in writing. And because of budget issues, we have eliminated telephone acceptance of complaints or calls on parenting time issues. So parties can either email, they can send a letter, or they can come in person to file their parenting time complaints. We have a reasonable parenting time schedule in Macomb County. It is on our website. Understand that that's not the norm. It's a guide for you to use for your clients when they come in and they're not sure what they want for parenting time. I was at a bench bar conference recently, and I was approached by counsel who said, you should put a caveat under your reasonable parenting time, because when people see that, they think that's what everybody has to have in Macomb County. That is not true. It's just a guide for those that don't know or don't realize what they're entitled to for reasonable, and it's always, you always have the ability to deviate from that to grant more or less, depending on what your client's capabilities are.